Hello, everybody. If anybody's here. Let me see. It looks like I'm live. Let's see. Do I sound okay? Can you see me? Can you hear me? Anybody? If nobody's here, that's kind of an interesting question. Okay. In any event, I am going to go through some of this complaint. Let me see here. Okay. Hey, Trakisha. Hey, Mish. Hey, let me see. Actually, let me check one thing. I'm supposed to have my chat visible now, but it doesn't seem like it's working. But that's okay. I'll have to get it next time. Let me see one more thing if we can get it to work. Oh well. Anyway, hey, thank you. I'm glad it sounds good. I've been working on my sound lately. I don't know how much of a difference it makes, but hopefully it's good. So anyway, this is the Fat Joe. Well, Fat Joe brought a lawsuit against this guy, Terrence Dixon, who I guess was his former employee, apparently for like 15 years. And that was, actually, I think I have it somewhere. This one. This one. This is the original lawsuit. Nope, that's not it. Let me open it for you. Oh, I can kind of see the chat on my screen now. Anyway, this is the original lawsuit. This was brought by Fat Joe, aka, oh, not aka, by Joseph Cartagena, aka Fat Joe. And that was brought by, he's represented by Joe Tacopina, who represented ASAP Rocky in his recent litigation. Let me see if I can make this better. How does that look? It's a little better. Okay. Anyway, that'll have to do for now. So this is the original lawsuit was fairly, I don't know, straightforward. It was what you would expect in a lawsuit. The most recent countersuit against Fat Joe is curious. Hey, Kat. Yeah, it's, how can I put this? The subject matter is very serious, but the way it is presented is not, I guess you could say. It's, I think, brought in a way that kind of makes a mockery of a lot of very serious topics. Kat can probably think of a better way to say that than I can. But here we are. There is a trigger warning, and I'll read it just because, I mean, it certainly deserves it. This document contains highly graphic information of a sexual nature, including assault. Additionally, there are graphic details of trafficking. There are more so details that are graphic than of trafficking, and other criminal activity orchestrated by the defendants. Okay, one thing to keep an eye on in this lawsuit is that, what's this guy's name again? Terrence Dixon. He forgets that there's more than one defendant for like long stretches of the lawsuit, so he'll just start saying defendant. But anyway, here we go. Plaintiff Terrence Dixon, buying through counsel, who is also named TA, which is confusing. Brings the civil action against Fat Joe, Pistol Pete, Rich Player. These are awful nicknames. Erica Juliana Moreta, who is actually a lawyer from Florida. Sneaker Addict Touring, Slate, Rock Nation, who is usually represented by, what's his face? Alex Spyro. So we could be seeing both Taco and Spyro teaming up, which is a terrifying thought. Oop, a little off the screen, aren't I? There. That's not what I wanted. Trying to make this look better. Yeah, this is better. Okay. Here we go. Sorry about that. So we have John Doe's 1 through 10 and Jane Doe's 1 through 10. This are just placeholders for future defendants. And ABC Corporations 1 through 10, same thing. Asserting claims for violations of the Trafficking Victims Protection Act. Yeah, that's a smart, Cat. I didn't think about that. Which I guess you can see Cat's comment now on the screen, hopefully. Yeah, whatever. So one thing you'll note is this Trafficking Victims Protection Act. There's not actually any trafficking victims that are plaintiffs in this action, so it's kind of making a mockery of the whole thing. Then the civil RICO and related violations under New York and Florida state law, including unjust enrichment, quantum merit, which is related to unjust enrichment, fraudulent concealment, fraud. I don't know what some of these are. Let's see, IIED and money laundering. I have no idea how you can sue for money laundering. This action arises from deliberate and sustained campaign of exploitation, wherein an internationally recognized entertainer manipulates and abuses a creative partner through an organized network of enforcers, associates, and shell companies. Defendants systematically engage in coercive labor exploitation, financial fraud, manipulation, intimidation, and psychological coercion. It's very dramatic. Against Plaintiff Dixon, all intended to enrich Defendant Cartagena and his associates while deliberately suppressing, silencing, and erasing plaintiff's substantial creative, artistic, and commercial contributions, which were foundational to Defendant Cartagena's professional success and personal brand. Preliminary statement. Let's see, this action, I feel like you just said this. For more than 16 years, Plaintiff Dixon, aka TA, you already said that like 3 times, dedicated his talent, labor, and loyalty to Fat Joe. During that period, plaintiff acted not only as Fat Joe's hype man, but also contributed as a lyricist, background vocalist, security team member, and creative collaborator. Despite his integral contributions, Fat Joe systematically excluded Defendant from fair compensation, attribution, and the substantial royalties and profits generated from his creative labor. Okay, now we're going to get to the interesting part. Plaintiff Dixon contributed lyrics, vocals, and creative direction to numerous commercially successful songs performed and monetized by Fat Joe, including but not limited to the hits Congratulations, Ice Cream, and Money Over Friends. Dixon's creative fingerprints, distinctive voice, and stage presence, who can forget his distinctive voice in the song Money Over Friends, are embedded in multiple critically acclaimed and commercially lucrative albums from which Defendant Cartagena continues to profit without recognition or fair compensation to plaintiff. Okay, thanks for reading this. Defendant Cartagena's Fat Joe's exploitation extended beyond financial fraud. He employed his industry influence and power dynamics to subject plaintiff to psychological coercion and economic control, forcing plaintiff into humiliating situations, including acts performed under duress and surveillance, accompanied by threats of abandonment in foreign countries if plaintiff refused compliance. And if I seem to be taking this unseriously, it's because I know what's going to come after this. Right, so far it sounds very serious. I definitely acknowledge that. But I've read more than just this part, and it's not serious. Let me see here. We have Torres, who are, Rich Player and Pistol Pete are accused of basically being the muscle in Joe's operation. This is the lawyer associated with both Fat Joe and I think also Rock Nation. These are supposedly the shell companies, Slate Inc. and Sneaker Addict Touring. Let me see here. Slate Inc. operated as the central financial conduit, systematically concealing illicit proceeds. At the same time, Sneaker Addict fraudulently secured PPP loans by falsifying business activity and diverting federal funds into the enterprise. Rock Nation, who I wouldn't have brought in to the litigation myself. Let me see. Rock Nation, the current management and representative entity for Defendant Fat Joe, knowingly participated in concealing, transferring, and manipulating plaintiffs' authorship rights and royalty interests. Rock Nation deliberately facilitated Fat Joe's unlawful conduct by filing a meritless lawsuit against plaintiff and his counsel to intimidate, harass, and obstruct plaintiff's legitimate claims against Fat Joe. There's more information about the business relationships between all of the entities. Again, this is supposed to just be the interest, the introduction, as opposed to anything substantive, but this is some of the more scandalous stuff, so I'll just read this the first time. Plaintiff was not only exploited financially, but also subjected to a wide spectrum of sexual coercion, psychological control, forced exhibitionism, and surveillance-based humiliation, including being compelled to perform sex acts under observation, being filmed or directed by a defendant in the presence of others. I'm sorry, I thought there was going to be another hyphen somewhere. Tactics designed to control plaintiff's body, erode his autonomy, and ensure silence. He's going to get into explicit detail on that, so we can move past that for now. These abuses were not private, incidental, or isolated. They were integral to the enterprise's culture of dominance and humiliation, enforced by the defense associates such as Pistol Pete, JB, and others, and sustained across numerous tour locations. I just realized this is an odd sequencing. Miami, North Carolina, Germany, Spain, and Wisconsin. You gotta watch out for Wisconsin. in Miami on Market America's corporate yacht and at its mansion properties, the defendant orchestrated repeated gathering of friends. The creation of fraudulent pay stubs. The use. That's such a leap. We're going from the friendly gatherings to the creation of fraudulent pay stubs. My goodness. The creation of fraudulent pay stubs, the use of W-2s while filing 1099s, and the concealment of... Sorry about that. Are textbook RICO predicate acts under mail wire fraud and tax fraud statutes. This is just a wild transition. Okay, the scheme furthers the enterprise's coercive structure. This is barely a sentence. We are the gathering. Plaintiff, female dancers, and minors. That sounds like a heading as opposed to a sentence, but in any way. Defendant uses status as a corporate sponsor, celebrity influencer, and financial control to compel plaintiff and others into degrading performances, often while defendant watched, recorded, or directed. Defendant also used social media burner accounts, as one does, including Bitj and Dr. Javag. Interesting choices, to issue veiled death threats and intimidation, such as, "You love your family, right? Fall back in 48 hours? I don't see how that's a... We let you live." This is a section at the end of a line, and I hate this. Anyway. These statements were interpreted by plaintiff and his legal team as part of a broader scheme to intimidate, silence, and obstruct plaintiff's participation in this case. These acts constitute violations of 18 U.S.C. 1512 and 18 U.S.C. 875. Isn't this supposed to just be the introduction? Am I missing something? Preliminary statement. This is not very preliminary. Then again, it is 775 paragraphs long, so I guess it can be. There's no way I'm going to get through this in one video, but we'll see how far we can get. Let me see. Yeah, Kat asked, why does it matter if his legal team interpreted it that way? I don't know, especially because his legal team would have been years after the fact. I assume. I think that's right anyway. Let me see. I need to find some of this. Okay, we can get to this. Writing it for the skim readers. Yeah, I know. It's crazy how quickly... I mean, it's a natural comparison, but people were comparing this case to the Diddy case, like the day it was filed, the day Kat shared it with me, which was, what was this filed, the 19th, which was, what day was that, Thursday? Or Friday? Yeah, Thursday. Even by Thursday, it was being compared to the Diddy case, which is wild. Let me see. As part of a coordinated cover-up, defendants submitted ghost contracts. I don't know what a ghost contract is, but it sounds delightful. And backdated split sheets to performing rights organizations, including BMI and ASCAP, omitting plaintiff's authorship credits. These actions not only deprived plaintiff of at least $600,000 in projected royalties, but also ensured his exclusion from future licensing and digital revenue. The fraudulent, backdating, and ghost contracts, I still don't know what that is, constitute predicate acts under 18 U.S.C. 1343, 371, and New York Laws 175. He's saying that the court has subject matter jurisdiction under 28 USC's all of the federal court procedural matters for the most part. 1331 relates to questions of federal law. In 1332 is diversity jurisdiction, which, funny question, or funny issue, the lawyer who wrote this, Tyrone Blackburn, actually, I think I have it open here. Is it this one? No. Oh, there it is. Here we go. So this is the other common kind of jurisdiction. This is the diversity jurisdiction. You'll see here that Blackburn didn't really do it correctly, but that is the other form. AI doesn't explain a ghost contract. It should. Okay. Let's see. This is, you'll see here he's defining everybody's name for the fourth time. Let me skip through this stuff. Venue. Okay, here we get to the part that I don't know what part we're getting to. It's the other annoying part. But this is just, you can use different numbers and letters. Use like 48A, B, and C. But we're not, that's not your problem. TA is an individual residing in New York. From approximately 2005 through 2020, plaintiff worked closely with defendant in, okay, here we go. That's our first example. There are like 10 defendants. So this doesn't mean anything. What page are we on? On page 8. So these are all defendants, right? So we have 1, 2, 3, 4, 5, 6, 7. And then potentially up to another 30. So potentially up to what, 37 defendants? So saying defendant doesn't really help at all. Same here. This is also singular. But in any event, plaintiff's work formed the creative and structural foundation for many of defendants' recorded songs and live performance, yet he was systematically denied credit, compensation, and royalties. Joseph, we know who he is, but actually, I looked up this. I need to show you guys this. I looked up this address, 15189 South River Drive, Miami. Let's see if I can share this. Here we go. So I don't know if this is the right address, or if like maybe over here it is, but I don't know if this is where Fat Joe lives. I could be honest with you. I'm not convinced by that one. So apparently Fat Joe lives there in Miami. Defendant Fat Joe has released multiple albums under labels such as Atlantic, Terror Squad, and E1. During his time working with defendant, plaintiff, authored or co-authored dozens of songs, including but not limited to Congratulations, Money Over Friends, Ice Cream, Cupcake, Blackout, Dirty Diana, Friendstar, Okay, Okay, Music, Ha Ha, How Did We Get Here, No Problems, I Chopped Up All the Way Up, 300 Brolic, Crack House, All I Do Is, Red Cafe, Winding on Me, Coca Baby, and Get It for Life. These songs appear on Jose 2, Dark Side Volume 1, Elephant in the Room, Fugitive, Loyalty, and other stuff. Let me see, factual. A ghost contract is an agreement that exists, but isn't formally documented or legally binding in a traditional sense. Yeah. I don't know about that. I don't know about Grok on that one, but we'll see. We have Pistol Pete, who is one of the henchmen, alleged henchmen. Same for Rich Player. Here's one we need to get to. This is Erica Mareva, who apparently it seems like it is Cat. I gotta pull up the Floater Bar website real quick. Juliana. Here we go. So this is the Floater Bar page for this lawyer. It says Erica is an individual residing in the state of Florida. She illegally represented herself as a legal agent and counsel despite lacking proper authorization to practice law in Florida. So I looked this one up. Let me hide this. You'll see here it's a little different than in the lawsuit, because here it says delinquent fees not eligible to practice law. Delinquent fees you can fix just by paying your fees. Usually it's not a big deal. But she is right now a member in good standing of the bar. So, seems like that's probably... an issue. She actively participated in creating and managing fraudulent corporate entities to conceal and launder the proceeds of the enterprise's illegal activities. Sneaker racketeering, involved in money laundering. I'm sorry, I'm just laughing at these entity names. Slate Inc. is a Florida-based entity serving as the central financial conduit of the Fat Joe enterprise. Slate facilitated the laundering of illicit funds derived from enterprise activities, including shell entities like Belidat LLC. Sorry, I was going to actually do a woo there. I decided not to. I don't want it getting clipped. Woo Inc. R4 So Valid LLC. Belidat LLC. I love that. Rock Nation, who they're just bringing into this lawsuit for no apparent reason, is a Delaware LLC, principal offices at 540 West 26th Street. I want to see that. What's 540 West 26th Street? It's by the High Line. Let me see. I can't get a very good picture of it. I think it's there. Maybe it's not this one. I don't think this is the Rockefeller office right here. I guess I can't be sure, though. Okay. Let's see. Rock Nation manages Defendant, Fat Joe's business affairs, has taken control over his music catalog, intellectual property since 2017. Plaintiff alleges Rock Nation received at least 10% of all income earned by Fat Joe. Appointed a director who directly supervised plaintiff. Acted as a joint employer. It's important. Aided and abetted the diversion of plaintiff's royalties through concealment of authorship. You can skip this part. Actually, didn't they say from 2005 to through 2020 before? I could have sworn it did. But it did. Yeah, it did. They just changed the years by 2 years. Okay. From 2005 through 2022, plaintiff, we're just going to define everybody again. Okay. Okay, over 16 years, plaintiff contributed substantially to defendant's creative output, stage shows, brand development, and operational logistics. Plaintiff undertook these responsibilities without a formal contract for 16 years. Okay, I feel like I've already read all this stuff. Throughout his work, plaintiff co-authored and or performed on numerous songs, including but not limited to All the Way Up, Congratulations, Money Over Friends, Ice Cream, 300 Brolic, No Problems, and Winding on Me. Let me see. Fat Joe and plaintiff negotiated the following compensation for his creative efforts, explicitly assuring him that he would receive 15% ownership interest in every track to which he contributed. That's insane. 15% of gross earnings derived from those songs. That's even more insane. Okay, if you own 15% of the song, you don't get 15% of the revenue. Because you have to pay stuff up that doesn't matter. But these two things don't really line up, is my point. But issuance of letters of direction to secure royalty and publishing payments through performing rights organizations, just ASCAP or BMI. I feel like I read that for the third time just now. In 2024, I can't believe I'm less than... Am I an eighth of the way through this yet? I don't even think I am. I think I have to do that another 7 times, more than 7 times, just to get to the end of this. This is insane. In 2024, plaintiff discovered that defendant, working with the lawyer and others with Slate Inc. Again, defendant, there's like 8 defendants, submitted falsified and backdated split sheets omitting plaintiff's authorship. These records were used to divert royalty income and construct a paper trail that falsely attributed full publishing ownership to defendant and his designated entities. These ghost contracts and falsified submissions. It sounds like he's using ghost contracts to mean just fake contracts. Ghost contracts and falsified submissions were designed to retroactively exclude plaintiff from economic participation while preserving the outward appearance of clean title. The resulting injury is twofold. Plaintiff was deprived of economic compensation, and erased from industry records, foreclosing future collaboration opportunities and denying him a public acknowledgement of his artistic contributions. Okay, one thing we can stop and reflect on here is what was I going to say? So the tolling of the statute of limitations thing, that was based on the fact that T.A. Dixon, the plaintiff here, said he couldn't have reasonably discovered any of these things until 2022. But it was 16 years, my guy. Like, you didn't notice that you weren't getting paid for 16 years? I mean, maybe in like 2019, you didn't get some money that you discovered in 2022. But in 2005, you didn't get your check. And then in 6, 7, 8, 9, 10, I'm not going to read through 2020. That seems like a long time to not notice any of this stuff. Okay, what is this spacing? That's the most offensive thing so far. Did he just switch spacing for no reason? Yeah, it seems like he did. Oh, I see. He got to number 100 and it changed. That's annoying. As late as 2022, defendant continued to assure plaintiff that payments would be forthcoming. I don't know which defendant, but that's okay. Things take time. They got your info already. It's been 17 years. These repeated delays were intended to lull plaintiff into continued loyalty while the enterprise reaped the financial rewards of his labor. As of the filing of this complaint, plaintiff remains wholly excluded from every royalty stream tied to the songs he helped create. His professional identity has been suppressed in service of defendant's economic domination and the maintenance of a fraudulent authorship narrative. Oh boy. Throughout plaintiff's tenure, Fat Joe and his enterprise, including Rock Nation, the other entities, deliberately misappropriated substantial sums contractually designated for plaintiff services. I don't know what that means. I do because I've read it, but otherwise I don't. These allocations were explicitly included in booking contracts, performance riders, and event agreements executed by defendants. Performance agreements routinely and explicitly allocated approximately $3,000 per show for the specific role performed by plaintiff as Fat Joe's primary hype man, not a secondary hype man, and creative stage presence. So it sounds like there's an agreement between like the touring company and Fat Joe that there will be a $3,000 allocation for the hype man, not that the lawyer, you file the... All right, let me finish reading this first. Not that this specific guy is entitled to $3,000. Mr. Big Play Bray says, real question, the lawyer you filed the lawsuit hasn't asked the New York Bar to investigate him. I believe he's under investigation by the Southern District of New York at the moment. And hello, Aaron. I brought this up a second ago, but this is a... I think this is going on right now, actually. Let me check the date. I don't know the outcome of this, but Blackburn was referred to the grievance committee of the Southern District of New York, at least last year. He's not somebody I would hire. I'll put it that way. Upon information and belief, on one occasion, Fat Joe pocketed a $30,000 payment from Live Nation earmarked for the All the Way Up tour and used it to pay off personal tax liabilities rather than compensate plaintiff. Again, what does earmarked mean? It doesn't mean that this specific plaintiff is entitled to that money. But let me see. It seems like the plaintiff is kind of conflating sort of internal budgeting versus what this plaintiff is entitled to. Your internal budget versus your obligations to pay. Your actual obligations to pay. Upon information belief, defendants instructed plaintiff's accountant to fabricate wage statements and inflate W-2s submitted to the IRS to make it appear as though plaintiff was paid appropriately, while in fact he was underpaid or paid off the books. So you're saying that they submitted W-2s. I mean, the IRS doesn't care if you're paid appropriately as much as they care that you report the payment. That doesn't completely make sense. Like, the IRS doesn't care if you're underpaid. They care about if you're paid off the books. But if you're being paid off the books, then why would a W-2 be inflated? I don't know why I'm asking these questions, and that doesn't make sense. Okay. Despite these explicit provisions, I don't know what provisions these are, because he was just talking about the IRS, but defendants systematically paid plaintiff only a fraction of this amount. That is either typically only $250 per show, delivered informally in cash payments, often without appropriate tax documentation or formal records. Plaintiff was intentionally kept unaware of these contractually obligated payments, as defendants deliberately withheld access to booking agreements, financial statements, contracts, and records of fees, performance fees. Plaintiff was thereby prevented from discovering the true extent of defendant's financial manipulations and his rightful entitlement to compensation. Again, he's just confusing budgeting with contracts, is what it sounds like to me. Oops, sorry about that. The plaintiff, I read that already. In addition, plaintiff was consistently entitled to receive daily per diem, as opposed to, weekly per diems. Payments contractually set at approximately $100 per day, intended explicitly to cover food, lodging, and travel expenses. Across approximately 200 performances, these per diems amounted to over $60,000. Due to defendant's intentional misappropriation, plaintiff routinely endured severe financial hardship. Some more about what I just read. Basically just saying that Fat Joe took his money. Okay, we're about to get to one of my favorite parts. Fat Joe's control over plaintiff extended far beyond mere financial exploitation. I think I read this verbatim before. Over 16 years, defendant cultivated a deliberate environment of psychological manipulation, intimidation, and threats to ensure continued submission, silence, and loyalty, despite abuse, exploitation, and humiliation. He likes his threes, doesn't he? 1, 2, 3. 3 here. 3 here. Okay. Is this where we get to Cuban? Yeah, I think it is. Let me see here. This isn't my favorite part yet. Basically, this part, he's just saying that there are physical threats against the plaintiff, and if he were to step out of line, he would get attacked. Exploitation and humiliation under duress. Throughout plaintiff's 16-year period working closely with the defendant, plaintiff was routinely coerced into engaging in acts with women, specifically brought by defendant Fat Joe to hotel rooms and gatherings following performances and studio events. Fat Joe frequently arranged and orchestrated these encounters, intentionally creating scenarios designed to reinforce plaintiff's complete submission. Plaintiff did not willingly consent. Instead, plaintiff submitted solely out of fear of immediate retaliation, which defendant repeatedly demonstrated would include financial punishment, sabotage, abandonment in foreign countries, or physical harm. On at least one occasion, plaintiff explicitly resisted participating in an encounter. Hey, Trakeisha. Oh, you've been here. Defendant immediately retaliated by canceling plaintiff's scheduled flight home, deliberately stranding plaintiff without money, shelter, or support, placing him in an isolated, unsafe, and highly vulnerable position abroad. He always does these 3 threes. I like that. Let me see. The defendant's use of coercive sex acts underpinned by the threat of job loss, abandonment, or physical harm meets the definition of trafficking by coercion under 18 U.S.C. 1591. Over 16 years, he estimates that he was coerced into more than 4,000 acts to maintain his standing within the enterprise. Here we go. Defendant's control was not limited to financial manipulation and abandonment. He routinely employed verbal intimidation and threats to maintain plaintiff's submission. As previously stated, defendant frequently told plaintiff no one exits terror squad in one piece. The defendant repeatedly referenced what happened to former terror squad artist Cuban Link, who was physically assaulted and slashed across the face, leaving him with permanent nerve damage and visible scarring. So this is a young Cuban Link. This is after the slashing. So this is he's just scrunching up his face here. Let me see if I can find you. The current picture of Cuban Link. Man, he makes his face a lot. Let me switch here. See, he just took a picture of the guy from his YouTube page. See, it's just his YouTube profile picture. See, he looks like a normal. Anyway. Yeah, Seamus says, I didn't see anything wrong with him in that picture. Yeah, he's just making a face. Like, he's not. It's not like has a raised eyebrow because he has nerve damage. He's just, like, has a raised eyebrow. Let's see if I can find a better picture, but. Yeah. I don't know. Let me see here. Beyond coerced acts, Fat Joe forced plaintiff into repeated acts of exhibitionism, designed to degrade and exert control under the guise of loyalty tests and group bonding rituals. Defendant, Fat Joe, I feel like we just read these. Okay, so this is the part. Hold on, let me fix this. I'm going to have to start getting creative with my, censoring of some of these sections, but here we go. On one occasion in Miami, after a concert, defendant brought a woman back to his hotel suite. He then ordered plaintiff to sleep with her in front of the group, insisting the bathroom doors stay open and shouting, "Get your something, something, something." Members of the enterprise stood in the room watching and laughing, with one individual remarking, "Yo, Joe, I'm not about to stand here and watch this fellow's assets." Plaintiff did not participate willingly. His compliance was driven by the credible and persistent threat of retaliation, including the loss of income, removal from the tour, or public humiliation. When plaintiff attempted to resist or assert boundaries, defendant swiftly retaliated. The plaintiff's pay was withheld. Again, we have another defendant. We don't know who that is. His travel plans were canceled or was threatened with abandonment in foreign countries. Rock Nation, which assumed management of the defendant's affairs in 2017, either knew or should have known. And here, the plaintiff's alleging violations of the Trafficking Victims Prevention Act. Which, I mean, even as alleged, I suppose it's possibly viable, but I don't know that, considering that these events took place over several decades, that he is the sort of victim that the TVPA was intended to protect, as opposed to, children or the violently trafficked. But in any event, he goes on to allege that each act constituted a RICO, usually called either overt acts or predicate acts. Each act was a separate predicate act under TVPA or RICO, entitling plaintiff to compensatory, punitive, and injunctive relief. I wonder what, like the woman in this scenario, or the girlfriend, I think he termed it. This, on one occasion in Miami, after a concert, defendant brought a woman back to his hotel suite. Like, that person seems like they could be a trafficking victim. Okay. Let's see. Fat Joe's conduct toward plaintiff was not an isolated deviation, but part of a broader pattern of control. Again, same thing, isolation, coercion, the same allegations as before. Enterprise's use of violent and threatening coded language. A key element of the Fat Joe Enterprise's operations was the strategic use of coded language to communicate threats, issue directives, and conceal violent and coercive acts. He does it again. Everything's in sets of threes. That's irritating. Okay, here we go. Here are some of the coded language. The Dern means Fat Joe. The Don means Fat Joe. I don't know if Fat Guy is the same as Fat Joe, but whatever. Boanches. That's kind of whimsical. Referred to as, I'm not going to read that. Payops. Coerced or violent acts. I don't even know how they got this one. That's something else. Ketchup, that makes sense. Matondum. Yeah, okay. He thinks alleging this in his own filing will become a truth defense. Yeah, it could be. That makes sense. I mean, it doesn't, but in theory, it makes sense. I'm not going to read this part. Okay. This is... You just saw that there are pictures on the screen. Those are pictures that are taken from... You see here. This guy found pictures of what he is alleging to be a high school victim, a high school age victim, and included them in the lawsuit. You're not supposed to do that, even if they are lightly censored, because you can still figure out who these people are. You can just find the originals, and then you know exactly what's being alleged. Now we have some lyrics, because of course we do. I will admit, they are a little disturbing, but here we go. Defendant Fat Joe has demonstrated a disturbing lack of remorse or discretion regarding his predatory behavior. Rather than conceal his actions, he had... Oh, I just got a client text. I got to check this real quick. Okay. That's interesting. In the song titled She's My Mama, Defendant delivers lyrics that, when considered in context or out of context, reflect an unhealthy and troubling fixation on underage individuals. Actually, they have the lyrics down here. I don't think I'm going to read these, but if you want to look them up. Also, I'll note that you can usually censor this sort of thing with, like, you know, an asterisk or something. Well, that's not Mr. Blackburn style. So, defendant's transportation, he's alleging that these crimes are associated with the trafficking. But what's weird is that the plaintiff was alleging them sort of on behalf of other people. Like, he wasn't a minor. The plaintiff wasn't a minor at the relevant times. The defendant's transportation of minors, even if they are violations, they don't really have any place in this lawsuit. And now we have Puffy and Fat Joe and DJ, not Khaled. And now we have an unnamed, and named rather, alleged victim, which is insane. And I don't believe Sean Combs is actually I think he's just in jail thus far, rather than, you know, somebody's been convicted federally. But I'm not going to read this section because it explicitly names a victim. I have no idea why he would do that. Explicitly identify a victim in litigation. A minor victim. Again, that's absolutely insane. Completely inappropriate. But here we go. coordinated retaliation attempts by Pistol Pete and Rich Player. I'm sorry, these guys just look silly. Following plaintiff's efforts to disclose the above, they tried to shut him up. Their actions were driven by fear that plaintiff's disclosures would expose them to legal liability, public condemnation, and criminal prosecution. This retaliation was limited to verbal threats or reputational smears. This doesn't make sense. This retaliation was not limited to verbal threats or reputational smears. It was deliberately operationalized through direct and coordinated outreach to a mutual associate named Percy, an individual who at the time remained loosely affiliated with the enterprise and maintained regular contact with plaintiff. Defendants Pistol Pete Torres and Rich Player Hospitre, two of defendant Fat Joe's most trusted enforcers, contracted Percy with the explicit goal of leveraging his relationship with plaintiff to facilitate a violent setup. Defendant's agents, again, we have a singular defendant. Defendant's agents saw Percy as a potential conduit to lure plaintiff into a confrontation under false pretenses. The objective of the setup was clear: to deliver a violent reprisal, either a brutal physical assault or a potential execution. That's bold. The motive was equally clear: to punish plaintiff for speaking out and to deter any further revelations that could damage defendant Fat Joe or implicate the enterprise in criminal wrongdoing. Let's see. I want to be clear, I did not do this highlighting. This is just in the original. Just to be clear, Fat Joe's not anywhere in here. And this part in red here, I don't know what that is. I have another phone call. This is where it gets interesting. While actively campaigning for former Vice President Kamala Harris's presidential campaign, defendant made direct threats to plaintiff from his Instagram burner account, BitG. I think this is right outside the White House, actually. I think that's the OEOB, Old Executive Office Building. I'm pretty sure it is. Defendants, now we're neither, this is just wrong. Defendants' disdain for current President Donald J. Trump is palpable, capital P. Numerous YouTube videos detail the level of hate he has for the current president and his administration. I'm assuming now we're just pandering to the DOJ. Huh. A real link. In the following Instagram message, defendant brags about having connections in the White House. Wait a minute. So wouldn't the part in blue be the part written by the plaintiff? Saying I own you? I don't completely understand where he's going with that one. Defendant was not lying when he said he had connections at the White House, as evidenced by the one-on-one meeting he had with then Vice President Kamala Harris. In addition to the one-on-one meeting, defendant, singular defendant again, moderated a criminal justice panel with Vice President Harris. He even had the audacity to bring one of his henchmen, RICO Enterprise officers, Rich Player, to meet with Vice President Harris. Here you get to Bill Clinton. Upon information and belief, while defendant was in the middle of moderating a criminal justice panel, he was actively using his RICO enterprise to set up the murder of plaintiff. Fat Joe brags about his political connections with former presidents. Those aren't terrible ones. Unbeknownst to President Clinton, he unintentionally accepted and wore a pair of sneakers that donned the name of a criminal RICO organization. This is true. I guess he did. Defendant's political reach does not stop at the White House. In August of 24, Fat Joe was presented with the key to New York City by New York City Mayor Eric Adams, who's had some legal problems of his own. Plaintiff believes that Fat Joe's confidence in openly threatening him, telling him to put a hit out at him, is due to this political protection from Kamala Harris and Eric Adams. In the following Instagram message, defendant confirms his RICO enterprise when he says, "Don't need to lift a finger, biggest in the game, willing to do it for free." Oh. There we go. Thanks, Kat. So saying this is Eric Adams. And he's getting a key to the city. And let me see. I don't even know what this is. In the following messages, defendant makes his intentions clear. He intends to do bodily harm to plaintiff. Friendo, you will get dragged. And he is warning the plaintiff to watch his back, as he has had ample opportunities to kill the plaintiff and or have the plaintiff killed, but be very careful, we let you live. I gotta be honest, like the ratio, it seems like it's the defendant talking like a lot of trash. Like, look at this. In the following IG message, defendant brags about strong-arming a YouTuber. Again, singular defendant. Brags about strong-arming a YouTuber. The defendant's IG posts are hinged in the other suit. Yeah, you told me that. I gotta pull those up. I should have done those first. Defendant brags about strong-arming YouTuber into removing and failing to release interviews of plaintiff where plaintiff publicly explained the harm defendant visited upon him. It's more corny than anything. This is okay. This is just more of him threatening the defendant. Oh my goodness. Where are you going? In the following messages, defendant attempts to lure plaintiff to one of his RICO enterprise businesses and further taunts plaintiff to lure plaintiff outside so plaintiff can get killed. He doesn't even... Oh, I see. I know, I see. Plaintiff believes that Fat Joe's attempt to lure him outside. Didn't I just read that? Oh my goodness. I think we're going to skip some of this stuff. Did we ever get into what a $1.50 is? Oh my goodness. And the following IG message, Pistol Pete confirms that Dr. Zervog belongs to him. Oh my goodness. This seems completely unnecessary, I gotta be honest. You see, usually in a complaint, what you're doing is you're explaining why you're suing somebody. You don't need to, like, get into all this stuff because it's not evidence. It's not useful for anything. You just need to tell them what you're suing them for. It kind of reminds me of the Justin Baldoni lawsuit, actually. With just hundreds and hundreds of paragraphs of nothing. It's not evidence. It can't really be used in any meaningful way. Oh, man. I am going to skip down to, I guess we do this part, some of the RICO stuff. I probably didn't even go far enough. Okay, we'll stop at this part. Upon information, believe kill all rats if an organization created and ran by defendants Pistol Pete, Fat Joe, and Rich Player. So this doesn't need to be capitalized. I think this is the one that Kat posted about, actually. But, it's terrible. Yeah, this is the TVPA still. Okay, this count 2's unjust enrichment. Under New York law, a cause of action for unjust enrichment lies where the defendant was enriched at plaintiff's expense, and it would be against equity and good conscience to permit defendant to retain the benefit. Usually unjust enrichment is only available where there's no contract at all. And as you remember from the beginning, the defendant was alleging that there was a contract. It was just being ignored or disregarded. So this one is actually probably not the best cause of action to go with, as opposed to breach of contract. They're usually irreconcilable. Okay, these are apparently the categories of enrichment that Fat Joe enjoyed. This is $3,000 budgeted per show, but paid only $250 per show. This is an internal budget. This is the amount that was actually paid. Those two things do not need to be connected or the same, so that doesn't really make sense. Per diem, same thing. That's budgeting versus contract. Royalties. This is nothing. Yeah, this is just contract-based stuff. So I don't really see anything there. Quantum merit is usually closely related to unjust enrichment. But under New York law, plaintiff may recover when plaintiff rendered services the defendant accepted. The plaintiff had a reasonable expectation of compensation and the reasonable value of those services is ascertainable. The doctrine applies even in the absence of a formal written agreement. Is meant to prevent a party from benefiting at another's expense. Quantum merit, sometimes referred to as a quasi-contractual remedy, meaning for some reason the contract fails. Oftentimes there's an intent to contract, but it just falls apart, or the contract's void for some reason, and one side gets the stuff and the other side doesn't get paid. And it's kind of like a gap filler. It's kind of a doctrine that steps in the place of the contract and makes sure that nobody gets, ripped off. But again, this sounds more like a contractual claim rather than a quasi-contractual claim. Let me see. And this is essentially just the same claim that he made previously. This isn't even really anything new that I can tell. Let me see. Fraudulent concealment pled with particularity according to federal rules for civil procedure. Under New York law, you have to have the existence of a duty to disclose arising from a special fiduciary or confidential relationship, concealment of a material fact, knowledge of the concealed fact, intent to defraud, reliance, and damages. See, these should be italicized. They're down here. I found one case in here that I wanted to show in particular. I believe it is one of these two. Let me see. I think it's this one. Hey, vague and ambiguous. That's okay. I'll show you my browser here. So you'll see, let's go back to the previous one. Reader. You see it says Lefkowitz versus Applebaum at 564. But then if you go to 564, there's only one sentence on page 564, and that is the plaintiff's remaining contentions are without merit. That's the only thing that it says. That's it. I wouldn't cite a case for that if I was the plaintiff. If all it says is the plaintiff's remaining contentions are without merit. That's generally, I mean, that's just me, but let's see here. Let's see. Constructive trust. This is a remedy. It's usually not a cause of action, but maybe it is in New York. In New York law, a constructive trust is an equitable remedy imposed to prevent unjust enrichment where property is acquired in violation of equity and good conscience. So, okay, here's one legal lesson we can learn today. Constructive just means fake. Anytime you see the word constructive, just hear fake in your head and you'll understand it. A constructive trust means something that is not in trust. Let me Google other examples. Constructive notice. That means you haven't actually received notice, but we're going to assume that you have for some reason. Constructive eviction. You haven't actually been evicted, but the circumstances in your apartment have been made such that they're trying to evict you and you were forced to leave. You weren't actually evicted, but you were effectively were. So it's constructive eviction. So constructive trust is when there isn't actually a trust over any assets, but they're going to sort of pretend that there are and try to recover those assets as if they were put into trust. Let me see. Again. Again, we're essentially repeating the allegations from before. Fat Joe didn't pay Mr. Dixon. So plaintiff respectfully requests that the court impose constructive trust, order disgorgement, require a forensic accounting. This is like an entirely separate thing. Enjoin defendant from further exploiting intellectual property. That's again redundant to the request for a constructive trust. The imposition of a constructive trust is necessary to prevent defendant from continuing to benefit from plaintiff's uncompensated labor. Okay. Up next, count 6, fraudulent misrepresentation. I think you just cited this a second ago. Is that up here somewhere? Yeah, it's this one, right? Is that the same case? 301. Yeah. That's weird. Look that one up real quick. So this is supposed to be page 376. So this is supposed to state the elements for fraudulent misrepresentation somewhere in this section. Here we go. Alleged defendant made a material misrepresentation. Misrep was made intentionally in order to defraud. Yeah, looks accurate. Good job, Mr. Blackburn. You did it. You did a good job there. If I never say that again. Okay. I try to teach a little bit. This one's so long. I feel like I have to skip over so much, just to try to get through everything. And I'm probably still not going to get through all this stuff in one sitting, but I'm trying to. Okay. I guess I can teach one more thing. There are special rules for pleading fraud. Here we go. These are the rules of civil procedure. Federal Rules of Civil Procedure. And when you allege certain, in general, you just need a plain and simple statement of why you're suing. But when you include fraud or mistake or anything that have to do with the defendant's state of mind, you need to be specific. Simply alleging fraud or mistake, as party must state with particularity the circumstances constituting fraud. So that is why Mr. Blackburn has that there. So the who. Usually you don't just explicitly do a who, what, where, when, but the fraudulent misrepresentations were made directly by Fat Joe, who exercised personal control over Dixon's compensation, authorship rights, and touring conditions. What? The defendant made multiple materially false statements, including the plaintiff would receive 15% ownership interests, 15% of revenue. Defendant would issue letters of direction, formally issued with ASCAP and BMI, and that plaintiff would be taken care of financially. These representations were made in New York, Florida, LA, and internationally. Wow, okay. Defendant made these misrepresentations as early as 2005 and continued consistently making them through 2020, during which plaintiff relied on them in good faith for 15 years. Plaintiff did not discover the fraud until 2024. How defendant intentionally and repeatedly made false promises to induce plaintiff to continue working without compensation. Plaintiff's trusted and loyal contributor reasonably relied on defendant's misrepresentations. Due to their longstanding professional and quasi-familial relationship, defendant's superior access to documentation, and defendant's role as gatekeeper. Damages: loss of royalty income, misappropriated per diem allocations, live performance under payment, denial of authorship credit for All the Way Up, All I Do Is Win, Congratulations, and Cupcake, emotional distress, and creative disenfranchisement. These damages are actionable under New York law and not borrowed by the economic loss doctrine, as the fraud arises from independent tortious conduct. Plaintiff's damages include out-of-pocket losses and losses of royalty-based earning potential. Okay, now we get to the civil RICO. So under 18 U.S.C. 1962, it's unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity. I haven't read the federal RICO statute for a while. I'm used to the Georgia one. It's different. It threw me off. Plaintiff Dixon has suffered a direct, concrete, and compensable injury as a result of the enterprise, including the systematic theft of plaintiff's royalties, the underpayment of wages, the permanent erasure of authorship, emotional trauma, credible threats to plaintiff's life, and out-of-pocket costs. This is largely just a restatement of what we read earlier, so I'm not going to go through all of that. Ooh, here we go. We have BDO, which is not a defendant at all, Rock Nation, Erica Maria, the lawyer, Rich Player, Pistol Pete, Sabado bank accounts. This doesn't make any sense. How can something be a money laundering hub if it's by itself? Anyway, So again, we're just restating everything we read earlier. This really could have been boiled down significantly. Predicate Act 1, forced labor. Again, repeating what we read before. Witness tampering. I haven't remembered that one. After plaintiff began disclosing the unlawful conduct of defendant and the enterprise members conspired to retaliate against plaintiff, seeking to prevent him from further disclosures or pursuing legal action. Threatening him. During the calls, Torres, this is Rich Player and Pistol Pete, urged Percy to help set him up, stating that Joe's family had to deal with him and the situation had gone too far to fix. The defendant was identified as the one giving the order, and phrases such as pound him out and get at him were repeated, signaling a premeditated physical assault or worse. Let me see. I don't remember this. Okay. Predicate Act 4. Defendant Fat Joe used violence and the threat of lethal retaliation to enforce loyalty and maintain control of the Fat Joe enterprise. These acts of actual and attempted redacted, I can't believe that's what was redacted, were committed either directly by defendant or by individuals acting in his direction and constitute qualifying predicate offenses. Specifically, defendant ordered 2 teenage boys to assault a man who had walked through a private circle in which defendant was standing. The teenagers, acting under defendant's orders, chased and beat the man. In self-defense, the man drew a firearm and fatally shot both teens. The tragic result was the foreseeable consequence of the defendant's reckless and retaliatory use of violence to assert dominance. That's horrifying, but I have no idea why that would get back to this plaintiff. That would seems like it would relate to the boys and the boys' families rather than this defendant. But defendant directed plaintiff and another associate to handle DMX. Really? After DMX became involved in an altercation with someone close to defendant. Following defendant's demands, plaintiff attempted to confront DMX, but DMX refused to come outside. Although nothing happened to DMX, plaintiff was under immense pressure and coercion, knowing that refusing the order could jeopardize his safety. I have questions about that. This is wild. Okay, we are going to move past some of this stuff. Take a look at the remaining counts. Oh, I think this may be the last of the counts, actually. Looks like it is. Okay, I think this is where they went, one of the places they went wrong. I think Kat actually noticed this first. Is anyone taking Tony Busby seriously these days? No, I don't think anyone has in a long time, really. This is definitely a very Busby lawsuit. This would be very much on brand for him. But I think Kat actually pointed this out first, so I don't want to steal credit. But it seems like some of this stuff should have gone down under here. In any case, wherefore, Plaintiff Terrence Dixon, aka TA, respectfully requests that this court enter judgment in his favor and against defendant Joseph Cartagena, aka Fat Joe, and award the following relief: compensatory damages in an amount to be determined at trial, but not less than $2.6 million. Triple damages under 18 U.S.C. 1595 for defendants' violations of the TVPA, including forced labor and trafficking. Not of the women or of the people who were actually trafficked, but for this plaintiff. Double damages, according to New York labor law, for defendant's failure to pay wages. So I don't know what portion of the 2.6 would fall under. Actually, no, these would be separate. So it's 2.6 plus these amounts. So we're probably talking $4 or $5 million here. Let's see. Equitable relief, including the imposition of a constructive trust, restitution of all funds and assets unjustly retained. That's usually related to constructive trust. A declaratory judgment recognizing plaintiff as co-author of all songs to which he contributed and confirming his 15% ownership interest and entitlement to 15% of gross earnings. I don't think you can really do that this way because somebody owns the song, right? And I don't know if Fat Joe is the guy that owns 100% of the song. And you can only take stuff from somebody who's a party to the action. So this might not even be doable the way he's alleged it, but in any case, he's requesting a full forensic accounting of all royalties, licensing revenue, and digital streaming income, tour budget disbursements, and publishing shares. That's actually not insane, an insane ask. Again, this tour budget disbursements thing he's just completely missing the point on. Just because something's budgeted doesn't mean you're obligated to pay it, or pay it to any specific person for that matter. Pre-judgment interest at the statutory rate of 9%, compounded annually from the date plaintiff's compensation royalties were due until judgment is entered. That is what pre-judgment means. Post-judgment interest at the statutory rate. That's weird. He's using pre-judgment interest under the state law, but post-judgment under the federal law. Reasonable attorney's fees under 1595, New York labor law 198, and such other and further relief as the court may deem proper. Oh man, I was trying to just fly through that as fast as possible and took almost 2 hours. And I skipped more than half of this. This seems to be a trend in these complaints these days to just put as many sort of facts as possible or alleged facts as possible into these complaints to try to put public pressure on defendants into settling. But in general, I mean, I've had cases that are billion-dollar Ponzi schemes with 50, 60 defendants, hundreds of people ended up getting sued, and the complaint is a fraction of this length. It's completely unnecessary. I hope this is a trend that goes away because it's really not good for the clients to be alleging things in this kind of in this style or in this fashion. I'll share another example real quick. Where is it? I mentioned earlier that this case reminded me of the Justin Baldoni case. And I want to show why I said that. This one is even longer, it looks like. Let me see, make it a little bigger. This one included at the end let me see here. Here we go. At the end of this complaint, did I not go far enough? It looks like they did it separately. But you can see in this, this is Justin Baldoni's complaint. This was dismissed, just I think in its entirety. But you can see it's just page after page of text messages and excerpts from newspapers. I don't know, IG messages, emails, and this sort of thing just shouldn't be in a complaint, because that's what the trial is for. That's what discovery is for. This stuff isn't evidence. Courts aren't going to take it seriously. And it might look good for the PR, but it's never going to get you anywhere. And these two just seem very similar to me. I'm much less offended by the Baldoni one than I am by the Fat Joe litigation. But they both kind of take the same style and approach. And I don't think either will be particularly effective. Yeah, Trukisha, yeah, it is. It is Tyrone Blackburn. But I understand why you would... I understand why you said Tony Busby. Because... two peas in a pod. But yeah, I kind of flew through that one. But I think I actually have some client work I have to do now that I just learned about while I was doing this stream. So I'm going to have to cut this one a little bit shorter than I wanted to. But yeah, I'm going to be ending this. I'll probably do another... Yeah, I know, Trukisha. Oh, Trukisha, by the way, I meant to thank you for the gift you sent. Thank you for that. I did receive that. That was super, super appreciated. But yeah, they're two peas in a pod. The funny thing is I think I mentioned this briefly, was that... what is it? Is it... Yeah, Rock Nation. I think they're represented by Spyro, usually. So we could see Spyro and Takapina up against Mr. Blackburn, which would be an interesting combination, for sure. But anyway, yeah, I'm probably going to do another video on this in more detail. I just wanted to try to get through everything, at least a little bit. I skipped quite a bit. But, yeah, I'm going to call this a day. And, I'm kind of regretting trying to do this all in one video. But, it is what it is. I'll do another video soon, probably, with a little bit more detail and, broken down a bit more. But hopefully this was, I don't know, helpful to lay out some of the groundwork. So, yeah. I will be wrapping up now, I suppose. And thank you, Trukisha, and everybody else for coming. And I just realized that I don't have my usual... where is it? My usual interface up. So you guys are just going to have to watch me try to figure out how to close this down. Yeah, Trukisha, I'll do another stream sooner, relatively soon. Hey, thanks, guys.